All right.
We are happy to have Sean. Sean, help us pronounce your name right.
Tuh-loo-check.
You had it right,
Tluchak.
Rick.
I love it. Okay, so Sean is a founding member of Tluchak, Redwood and Culbertson, PLLC. He's been practicing law in the greater Richmond area for over 22 years, and he's litigated real estate and construction law cases for 10 years before focusing on real estate transactions. He's helped dozens of local investors with their financing, wholesaling, and purchasing needs, and titles and searches are a necessary part of that real estate and something we should all know about. Join us for the ins and outs of titles and how they play a role in real estate transactions, and welcome, Sean.
All right. Well, thanks for having me. I'm not seeing the screen share. Oh, there it is. All right. I guess I'll start from here to try to share this screen. I'll tell you what. Interesting. The only window I have up isn't showing. So do you want to go ahead and start it on your end, Suzanne, and then I'll just tell you when to switch screens.
Okay.
I mean, Anna.
Anna, he means you.
Anna, you're muted.
I'm working on getting the presentation up. So maybe Sean, tell them a little bit about yourself right now until I get it up, okay?
Yeah, sure. So, yeah, Rick, thanks for the introduction. I have been doing this a long time, and I come from a unique background for settlement agents, and that's because I did do real estate litigation and contract and construction litigation for 10 years before I started doing real estate. My former law partner had done real estate since the 70s, early 70s, and when he passed, I tried to step into his shoes, and I tried to do both, and I found that to be impossible. You really can't litigate and do real estate at the same time because you can't be in a courtroom and on your computer at the same time. So I quickly learned that I had to pick one or the other, and that was when real estate started booming. It was in 2011, and it was a time where I actually had a decent little cachet of investors already. I had a little group of real estate agents that I worked with, and it took off. And that's what I've been doing ever since. Right now, we're doing, pretty much about 70% regular residential real estate closings. And then a lot of my practice is investors. Like I said, I've been working with investors since 2009. I probably have about 30 that I work with regularly. And probably as many as 50, that do one-offs every once in a while with my firm. I know that some of you guys are from Fredericksburg. I'm interested to hear about that because it's such an interesting dynamic and difference between Richmond and Fredericksburg. Believe it or not, the way that closings are done in the Fredericksburg area is actually a lot different than the way that it's done in Richmond. I'm not bragging, but I'm going to say that we're a much friendlier area to do business in as far as how the settlement agents and the title companies and the attorneys work together. Our pricing is significantly different from what I see, and just the way that we do it here. And so I'm always curious to hear some of the stories from the Fredericksburg investors. I can't see the screen yet, Anna. Do you?
It's right here. Can you see that? It should be up.
There
Is it
we
not
go.
up?
I see it now.
Okay, good.
Yeah. So just go to the next slide. Is it making you scroll?
Yes, it is. It's making me
All right,
scroll.
Interesting. Let me.
Keep going?
All right, just keep
Okay.
going down until I guess what would be the first slide. As you can see, I have a couple of law partners. Katie started about 8 years ago, and Walter's been with me for 2 years. And I'm going to be honest with you. I'm not just going to talk to you about title searches tonight. For me to talk about that for an hour would be the most boring thing in the world. I'm going to do an overview really of a lot of things that I see in real estate with my investor clients, because I think there's two things that I always have a focus on. Number one is how not to delay the transaction, right? And number two, to make sure it gets closed. So I want to talk about some things that will start it off strong and finish it strong. You go to the next slide so I can, yeah. All right, so I do want to start with that, right? The title search is an important thing. And I cannot tell you how many wholesalers and investors I work with that bring me a contract. I know that y'all love the one slip of paper contract, and that's fine. I know that's the easiest thing to get signed, but people bring me contracts all the time that just aren't signed by the proper party. And that's important for two reasons. Number one, it's unenforceable, right? You found this killer deal. You're really excited. You're going to close on this property. You're sending it to your possible end buyers. You're sending it to me to start the title search. But if that person doesn't own the property and they're not the sole owner, or you don't have all three owners, it's not even enforceable. You can't even get specific performance of that contract. You can file your memorandum if you want and try to tie it up. But if any attorney where there's weight in gold comes in there, he will go ahead and he could file slander title charge against you. All those kinds of things could happen, but you don't have an enforceable contract. That's number one. The number two thing is delay, right? The way that I work is when my investors send me that one-page contract, I immediately forwarded it to my title company and I say, go ahead and order this title search. My savvy investors know that's got to happen to kick the whole process off. Title searches are out 2 weeks. So if you told that client that you're going to buy it in 3 weeks, I better order it the day that you get that contract signed. If you don't have the right information and my title company goes out, like, for example, I had one just the other day, they sent me a contract that had, I guess I'll make the name up a little bit, but it was Brian Taylor. All right. Well, I get the source deed back, and a Brian Taylor did take title with a Louise Taylor in 1978 as tenants by the entirety with right of survivorship, meaning they're married. But I asked my client, I said, how old is Brian Taylor? Well, Brian Taylor's 40. Well, that wasn't the Brian Taylor that was married to Louise Taylor, right? That was the son. And he didn't ask the right questions to get to that point to have that knowledge. The way that you start is you look at the source deed. And there's a couple ways to get that source deed. The first way is to ask them. It's amazing how many people have kept that recorded deed in a drawer, in their storage room for 30 years. But that is the starting point. If their name isn't on that source deed, then they're probably not the owner, or there's a reason, why that's the case. Mainly somebody died. If you can't find the source deed, then you'll get the tax records. All right. And if the tax records are in a different name of the person you're talking to, then you have to ask the right questions to find out why that's the case. Finally, go down and pull the source deed at the clerk's office. And that's kind of what people ask me about all the time is, well, how hard is that? Well, it really depends. Just like all lawyers, I'm going to give you that answer, right? But if it's in the last 20 to 30 years, it's really not hard. It's basically a Boolean search. Any clerk's office is going to have a slew of computers set up. Usually you'll find a clerk that won't mind helping you a little bit, depending where you're at. And you simply type in the name, the last name, and they will pull up the transactions in that person's name. You'll then be able to scroll down and you'll be able to find the first entry of that name and see if it matches the property address. And when you pull up the deed, you're going to see their name. A lot of times they'll hold title with somebody else, especially if they were married or they bought it with a brother or sister. But that's your starting point. And if those things don't match up with that person's name, then we have to figure out why, right? But before we get to that point, we're going to have to understand the types of deeds. So there's 4 main types. And the first one is the one that you always see when it's a husband and wife. And I'm speaking to Virginia particular on this because I don't know anything about Florida. I'm sorry, they might have something completely different. But the first is tenants by the entirety with right of survivorship. We kind of raise our hands, hooray, when we see that if we're buying a property from the surviving spouse, right? Because there's 2 reasons for that. Number one, if there were any judgments against the deceased spouse, they didn't attach to the property. That's what we love. Number 2, they owned it together with right of survivorship. So she's automatically the owner and nothing else has to be done in Virginia. Simply producing a death certificate is enough to show title in her name and convince the title companies to insure it. The other one is joint tenants with right of survivorship, which is very common with, brothers and sisters when they buy it together, or close friends or boyfriend and girlfriend because they're not married. They don't have the protection afforded by tenants by the entirety. Again, we jump up, we're happy because nothing needs to be done except produce a death certificate. The third one, when you have multiple owners, is tenants in common. And this is something that a lot of people don't understand, is tenants in common in Virginia is the default. So if you had an attorney 10 years ago that screwed up and put it in Sean Tluchak, and my wife, she wouldn't take the Tluchak name for some reason. I don't know why, but Sean Tluchak and Lisa Rossi, but didn't put the tenants by the entirety with right of survivorship, the default, even though we're married, that is going to be tenancy in common, which can be a nightmare. And it's a nightmare for several reasons that we're going to get to in a second. But the fourth one is fee simple. And that's when just somebody owns it singularly. And you a lot of times won't even see fee simple. It'll just be to Sean Tluchak. And then the default on a single person ownership is fee simple. But that leads us to where what happens, all right, it is tenants in common, or it's just one owner. What happens when someone dies, right? The first thing you have to do is ask if there's a will. I cannot tell you how many times people come to me, they've said, hey, this is, Bob is the son, he's selling it. I'm like, all right, well, that's great. Did you ask for the will? And they say, oh, no, I didn't even think about that. Well, the will in Virginia is going to be what dictates where the property goes. And I know that sounds like common sense, but it doesn't do that unless one thing happens, and that is the will gets probated. So many people think that a will has an effect on the title to property because it's in their hand. It doesn't. It actually has no effect on the title to property until it is probated. So there's a couple things that we have to do. Number one, we say, all right, well, send me a copy of the will. And sometimes I'll look for probate information. It's rarely on there. I can also have a quick search done if we have access to that clerk's office to see if the will is of record. But here's the thing. Let's say somebody dies at Fredericksburg, they probate the will, but they own property in Richmond. Well, that will has to be recorded in Richmond too, to then have the effect on the property. And so we have to get a certified copy from Fredericksburg and record it in Richmond. And so it's something to be aware of. The reason I say all these things, because that stuff takes time. Now, if somebody dies in Florida and I have to record that will in Richmond, we have to do something even on top of getting a certified copy. It's got to be an exemplified copy of the will. An exemplified copy usually has to be signed by either a judge or the clerk themselves. And it's a process. It's like $60 depending on the state. And usually it's a 2 to 3 week delay. Those are the things we hate. We hate delays. So you got to be on top of these things right from Jump Street. Now, here's another thing. People say all the time, well, I got a copy of the will. I'm the executor. Well, a lot of times they're not the executor. A lot of times somebody else was the executor that died. So if they're not appointed a subsequent executor in that will, then they may only be able to become an administrator of that estate, or they may have to apply for court approval. And so we got to look at all of those factors to see if we can close that thing in time for you. Now, if there's no will, that's where it gets complicated, right? Then I have to ask the person to make a family tree. Is anybody familiar with doing family trees? I think I can only see 3 of you, but a family tree is a very important thing, in my opinion, for wholesalers and flippers to learn how to do. And it's really not that difficult. But essentially what you do is I turn the piece of paper sideways and you put the person that died right at the top. And then it splits. Every time somebody dies, it splits again. And then we can see, all right, mom died. She has 3 kids, Bob, Jane, and Mary. All right. A lot of people think if Mary died before her mom did, then we don't have to worry about her. That's not the case. In Virginia, a predeceased heir, it will pass down to her kids. So if she has kids, we have to start that little tree again. And we put an X where she is, we put the date she died, and then we put 2 arrows with the 2 kids. If one of those kids died, guess what? Those kids will also take. And so that tree can become very, very deep rooted very quickly, especially when you're talking about older families or big families. And if we don't have all of those people on the contract and then on the deed, then first of all, we don't have an enforceable contract. And second of all, we don't even have a good deed. And I cannot tell you how many times I've gotten to the point where I've done my investigation and said, hey, what happened to Mary's kids? And somebody says, what? Or what's going on with Mary? And they just said, we didn't even think about Mary. And a tip that I give everybody is that if you are buying property from somebody who received it through somebody that died, search an obituary online. So many times I've gotten what was alleged to be the family tree, and then I look at the obituary and there's 5 names that nobody mentioned. Sometimes it's because they didn't want to deal with that person. Sometimes because they're angry with that person. Sometimes it's because they forgot about that person. Other times it's because they weren't the one that prepared the obituary and had no idea about those people ever at all. It happens. Another thing to be aware of is that a lot of times people think that if they're married to someone and that person dies, they automatically get what they owned, even if they weren't in the will, or even if there was no will. And of course, that's not the case. In Virginia, if I had kids from a prior marriage and I died, my wife doesn't get it all. She only gets 1/3 in Virginia. My kids from the other marriage, or even if it wasn't a marriage, they split 2/3 of my estate. That's always a shock. And so we have to ask the right questions from the beginning, because there's nothing worse than wasting 2 weeks of a title search to find out, guess what? We got to go back out and search 3 more kids. And what happens when we do that? Well, they've got judgments against them, right? Let's go down a little. And Anna, can we scroll a little down?
Sorry. I heard you say we got
That's
judgments,
okay.
and I didn't, and let's go down a little, but I didn't know you meant down on the screen.
I got you. I'll just do this when it's time to move down.
I can't see you the way the setup is. That's the problem. So just
Oh,
tell me
I
to go to
got
the
you.
next
Yeah.
slide or something.
Okay. All
Sorry.
right. That's okay. That's all right. Yeah. And so another thing, we mentioned this about, having the proper sellers. Another thing I see when I see investors working together is a lot of times they're signing contracts in their personal names. They're not designating themselves as member manager. When they're signing for a corporation, they're not designating themselves as president. I would not hesitate when I am entering into a transaction with another investor that's selling through his LLC to ask for a copy of their operating agreement. And the reason is because for the same reason, if you don't have both the heirs on a contract, if the proper party to the LLC hasn't signed that contract, it's once again unenforceable. And that doesn't even just mean that both members have signed it. You want to make sure there's not somebody designated as a manager that should be signing those contracts. You want to make sure that some of them will say this. They'll say that both members have to sign to convey any assets of the organization. And if only one has signed it, it may not be enforceable against the LLC. And the reason I tell you these things is because a lot of times you're getting deals, right? And so when you're getting a deal, you want to be able to enforce it. It'd be one thing if you're paying market value for something. I mean, if you're going to turn around and sell it, you're not going to make anything. But you want to be able to hold parties to the transaction, and you don't want to allow them to slip out of it because of a mistake that was made in the beginning. In here, you see some things that we kind of already went over with the intestate heirs. Another thing I see all the time is power of attorney. Oh, I got power of attorney from my mom. And so the investor will bring me the contract and it is signed by somebody as power of attorney. I lost my screen. Do you want me to try to share mine again?
Yeah, because like Rick T, some people are getting kicked. Zoom is doing some really crazy things tonight. Some people are getting kicked out. And so I needed to let Rick back in unless Rick Banez wants to.
All right, let me try.
Share it.
See, I'm interesting. I'm clicking shared screen.
Yeah, it's
and
weird.
The only other screen I have open is my PowerPoint. Let me see.
Let me just change the hosting to Rick and then he can admit people. How about that? I'll do that because I've got somebody else. I'm just because of the hacking earlier, I'm just kind of scared to admit people too. Somebody named JD. Rick, do you know them? I'm going to make you the host, Rick. All right, now I'm going to go back to sharing my screen. Rick, you're the host. You can
Okay.
look into admin, okay? All right, there you go.
All right, let me.
Am I still on the
Okay, I
same
can see.
slide?
Yeah, we're talking about power of attorney right now.
Yeah,
and how
down
I
at the
often
bottom.
have investors.
Yes.
Yeah, I often have investors come to me with a contract that is signed by somebody that's the power of attorney for their mom or dad or whoever. But there's a couple things you have to make sure that are done. First of all, you want to make sure they have the original power of attorney. A lot of clerks' offices, in order to record a deed with a power of attorney, require the original. And so you want to ask them if they do have the original. You then want to send that to me with the contract. Title companies require very specific language in the power of attorney in order to convey property. Sometimes you see these awful power of attorneys that come from online systems, and they have boxes that have to be checked in order to do the things in the box, and they don't get checked. And if they're not checked, the power of attorney is not going to be sufficient to sell property. It's super frustrating for everybody. That was the whole intention. But the power of sale has to be in the power of attorney. So it's something that we always want to see right away, because God knows we've had those scenarios. What happens is if somebody doesn't have a valid power of attorney to sell property, then the only way to sell an incapacitated person's property is to have somebody appointed a conservator of the estate. And that can take a long time. I mean, you could be looking at 3 months, and you might open it up for somebody contested. And so it's really frustrating. All right, let's go down a slide. Can you keep going down a little bit more? Just a little bit more. There we go. This sounds like common sense, but when I get the contract, well, all right, go back up.
Did you want earnest money deposits, or do you want the next slide?
It's the one before that. You had it good. You had it good for a second.
Okay.
Right there. Okay. So I get this all the time. I get a contract, and it's got 1818 Main Street, Richmond, Virginia. And that's it. That's all the description of the property I get sometimes. Well, I don't know how it is in Florida or Fredericksburg, but you can have a Richmond address here, and it can be in the county of Henrico. It can be in Chesterfield. And sometimes it can even be in Hanover. So it's really important to give me the parcel ID number. It's really important to let me know the county that it's in and the address with the correct designation and a zip code. All of those things can prevent problems happening in the title search process. A lot of times people will think their address is one thing, it's their mailing address, but it's actually the mailing address for the parcel next to it, and their tax parcel ID number has another address they weren't even aware of. It happens. And again, all those things will move you back in time. And title examiners, all they get from me is the contract. I don't go online and pull up a tax report or go on MLS. I just forward the contract, and that is their jumping off point. So the more information that's in there describing it, the better. Another thing I see all the time is sometimes investors will put in additional terms, side lot to convey or something like that. Well, that's ludicrous, right? Because that doesn't mean anything to me. I've got to have the tax parcel ID number of that side lot, and I don't want it in additional terms. I want it in the description of the property, because that's what my title company is going to look for. Recently, we've been running into a lot of issues with surveys, boundary lines, and fences and that kinds of thing, mainly with driveways, right? People are buying property that's in a little bit of a rural area. The driveway comes in from the right, and they're not going online and looking at their property on so many counties have these great resources where you can actually see the tax map, right? And then you click on another one, it'll show the aerial view, and it'll show the lines within the aerial view, and it'll show the lines on the tax map. And you can see that the driveway clearly isn't within those lines. So we don't just ignore that and say, we'll just send it to Sean. Say, hey, look, I looked at this. I've got a little bit of a concern that the driveway might not be on the property. And then a couple of things can happen. I can say, hey, look for an easement. Let's look particularly for an easement. Or can you pull the property next to it and see if there's anything about that I need to know about? Because if I do it right then, the searcher sometimes has to go to these clerk's offices. And so if they're down there, they can pull all that stuff then and have it in the title binder when I get it. And so super important to try to be ahead of those things. Next slide.
I think for some reason it takes a moment to load on the screen. I'm not sure what's going on with that, but.
Okay. So EMDs, the reason I talk about this, it goes back to what we first started talking about, and that is making your contract enforceable. You guys look like you're a little more seasoned than some of the investors I talk to sometimes, but so many times I get a contract that has $100 deposit and they think they don't have to give me the $100 deposit. Well, if I don't get that $100 deposit with that contract, and 3 days later, the seller's attorney calls me and says, hey, I understand you're representing this buyer. Can you send me proof of that deposit? And I say, I don't have it. Guess what? He says they are selling it to someone else. That contract is terminated. And that, I'd say that's 50% of the time when I see a low deposit is I actually don't get it. And look, I'm not going to track down your deposit for you. I've got 10 contracts coming in every 3 days. You know, I'm not babysitting your deposit. And if sometimes it says $100 deposit with seller, don't do that, right? That deposit's gone. You want to have it with me because then I can show it on the settlement statement. You're going to get credit for it there. And I love it because then if your deal doesn't close and I haven't been paid for my title search, I can use that to pay for my title search. I'm just kidding. But yeah, just make sure you do that right. And when you bring me the deposit, it's incredibly helpful to put the address on the check, the name of how you're taking title. A lot of times I'll get a check in the name of Joan Smith. Well, guess what? She's buying it under, you know, America's Fabulous Home Buyers. And I can't put the 2 and 2 together without doing a little bit of heavy lifting. And all this sounds obvious, I know, but all these things are things that make my job harder. When my job's harder, it makes it harder for me to help you get from A to B. Please understand, though, the thing is, I don't really release a deposit without a release signed. There's ways I can do it. I can send a letter, but I usually got to wait 45 days. If I don't get any response and it's obvious, I can sometimes give a deposit back, but just something to be aware of. Next slide. All right, this time I'm not talking about a POA, power of attorney. We're talking about a property owners association. I've seen my investors get bit by this. And the reason is because they're buying it from somebody that might not have lived in the property because it's an heir, somebody that hasn't lived in it very long, somebody that didn't take care of the bills ever and just isn't aware of it. But you need to know if your property's in an HOA or a POA. And the reason is because you are going to have to get a property disclosure. In Virginia, it's a big deal because the seller might have owed 8 months of dues at $200 a month, and that follows the property in Virginia. Unless it's wiped out by foreclosure, that is going to follow the property, and that's going to be something that you're going to be responsible for as the new buyer. Now, you can always go back after the seller. Good luck, right? You know, if you got this thing at 40% of its value, that money's probably gone by the time you realize where you're at. And so that's why I always ask people, please put somewhere in the contract whether or not it's in an HOA. If I know it's in an HOA, then I have a master list of companies and contacts, and I can help you get where you need to go to order that POA package. The other thing you're going to be able to see from your association package in Virginia, it's required. They have to tell you if there's any violations. That might help you negotiate a better deal in your contract and say, hey, look, you know, I see these shutters aren't, you know, approved, or this shed in the back was never approved. I'm gonna have to tear it down. So give you a little bit of leverage with your seller. Next slide. Go down.
Don't do it.
Yeah, I mean, rent backs, they're just terrible, especially on investor deals. If you've closed and funds have been released to a seller who is probably what we call a distressed seller anyways, and you're letting them live in the property, you are really exposing yourself. Virginia used to be one of the best states to evict in, and that was brought to the attention of the world through, I think it was a report done by some people from Oxford, and it was a lot of negative attention to Richmond in particular. And so we have made it harder to evict people. So instead of like a 30-day eviction, you're probably looking at 50 or 60 now, where we are. And so just don't do it. You don't want to be in any kind of litigation, especially with a distressed seller. You get a judge that feels bad for them, feel like they're taking advantage of. You never know where that could go. Heaven forbid they end up at legal aid. They might try to set your whole contract aside. But anyways, if you are going to do it, just make sure you get a good deposit. Make sure you include a daily fee that starts on the day of the holdover, and make sure you have an actual rent back agreement. And what I mean by that is, don't have an addendum that just says seller can rent back at $10 a day for 30 days. That's not a rent back agreement. That's crap. Okay. What we need is basically a 2-page lease that specifies you can get attorney's fees. You can get per day penalties. You can get all kinds of stuff. It's going to have a lot of things in there to protect you. It's going to state that they got to return the property in the condition it was at the time of closing. All that needs to be stated. And here's another thing, for my wholesalers, usually there's a bunch of them. Maybe there's none in this group. Maybe there's people that buy from wholesalers. But once the contract is assigned to you, or you have assigned the contract, the person that signs the addendum is the end buyer. And I cannot tell you how many addendums I've gotten after a wholesaler has assigned a contract signed by the wholesaler as if he has done something. He has done nothing. He doesn't have any right to that contract anymore. He has a right to the fee that he got for selling that contract, but he is no longer the holder of that contract and shouldn't be signing anything between the seller and the end buyer. Very important. Again, because of enforceability, right? And this is, again, common sense, but copy me on an addendum as soon as it's ratified. A change in the purchase price changes my title work, it changes my HUD, and it changes how the deed has to be prepared because it has to have the right consideration on it. So all things that seem like, oh, what's the big deal? Purchase price changed by $500, changes everything on my end. So get it to me as soon as you can. Next slide. So I know that most of the investor contracts don't provide for any inspections. It's as is. They can do it for informational purposes, and that's fine. But a lot of times what I'll see is they'll say they can inspect it within 14 days for any good reason and get out of the contract, given notice to the seller. They forget all the time to give the notice to the seller within the 14 days. Some contracts they'll use, they don't even realize it provides for written notice. And if written notice is required and you don't give it, you waived your right to an inspection. And I know it's a big deal particularly for wholesalers that they be able to sell that property in a certain amount of time. And if they can't, they usually want to wiggle out of it. If you can't wiggle out of it because you're outside your inspection period or your due diligence period, then you're still obligated on that contract. And depending on how it reads, you could be sued for damages because that seller turned around and sold it to somebody else for $1,000 less. In theory, he's got a case against you. Septic inspection is where I see a lot of people getting a lot of trouble. It's where I see money lost, which is what you care about the most. And that's because they buy property and they don't even realize it's on septic. How does that happen? Well, same thing with the POA. They had no idea because they just moved in a month after mom died. They've been flushing the toilets and nothing's happened. Everything's fine. They're not paying a bill. They don't even think about paying a bill to the county of Henrico or wherever it may be. And everything's great. Well, the investor buys it, flips it, sells it to a 4-person family. And next thing you know, it's gurgling up, and they find out they're on a septic where if they didn't list it on a septic can be real problems. And it's one of the big ticket items that I'm sure most of y'all know. So how do you know that it's on septic? Well, sometimes you can find the bill. You can call the county. One thing you want to be careful of is you want to make sure you're not just asking if it's hooked up, because you can have a county hookup that's not active. So you want to make sure it's active. Also, you want to see if you can get a copy of the septic approval, because if you're a flipper and you want to add 2 bedrooms on that thing and the septic's only designed for 2 bedrooms already, you might have an issue there when you go to put it on the MLS. And guess what? You're selling a 4-bedroom house with a 2-bedroom permit, and that can come back on you and potentially your realtor. Water tests. I don't know how anybody ever closes with a well without a water test, but that's one of the things where I've seen somebody drop $20,000, and I've seen a property condemned because they simply couldn't get a well put in, and it was impossible to connect to the county. So I would urge you to get one. Don't skip that step, even though it seems like a great deal and the water seems to be perfectly clear and fine. You never know what's actually in there. Next slide. I saw that you have somebody coming in a couple of weeks to talk about mobile homes. I assume manufactured homes will fall under that penumbra. That's fantastic. That's going to be great. I will probably ask to be a visitor. I would love to hear what they have to say. I am running into tons of issues with manufactured homes on flips. And the main reason is because my flippers are buying it all cash. So my title company says, all right, all we want to have is the affidavit of manufactured home recorded. If I can see that it's been in the tax records for 15 years, taxed as having improvements. If somebody can send me a picture showing that the foundation is attached to the ground, that's enough, right? And it should be enough, but it's not enough for lenders. Lenders are requiring that. This is crazy, but they want you to prove a negative. They want you to prove that it's not titled with DMV. And that sounds crazy. We should be able to do that, right? You ask DMV. DMV will tell you, we can't find any record of it. Well, that's not enough. What I should have said is they want you to prove it's been surrendered from DMV, meaning DMV has surrendered the title. But if it was never titled, with DMV, which is sometimes the case with the manufacturer's home, then it's impossible to prove that it was surrendered by DMV. And so you ask DMV, you will say, can you provide evidence the title has been surrendered? And they will say, no, we can't. We don't have any record of it. And the lenders will say, without proof of the surrendering, we can't insure this transaction. We can't loan on this transaction. So we had a couple deals fall through because the lender essentially wanted you to prove something doesn't exist. And it was super frustrating for the buyers. And as you can imagine, for the sellers, they basically had to start shopping people that could buy with a conventional loan through the kind of lender that would know how to approve something like that. But I put kind of what you have to go through here. Another thing is when you're buying a manufactured home is look for the plate. You know, there's going to be a plate inside the home somewhere. If you can't find that anywhere, that's pretty bad, right? There is a website that we can go through to start tracking stuff, but it's like a treasure hunt almost when you start trying to figure out where these things came from and see if you can find the original VIN number, or there's a HUD number, I think it's called. But I'm glad you're going to hear about more of that in a couple weeks. Next slide. All right. The reason I'm talking about bankruptcy is it's another deal killer, right? And a lot of times people don't ask their sellers if they're in bankruptcy. I know it's a hard question to ask, but if someone's in bankruptcy, they can't sell the property. You know, it's kind of common sense. The trustee has to approve them selling the property, which, here's the thing. You've gotten a contract for $30,000, right? The assessed value is $100,000. You know that it's worth $100,000. Well, if anybody looks under the fingernails of it, they may not approve that sale in bankruptcy, and you've wasted a ton of time and effort on a property. So you want to make that decision. Is it worth me going through that process of getting the motion to sell? And who's going to foot that dime? If the bankruptcy attorney wants more money, who knows? But you got to be ready for those things and understand them. The worst situation is the title companies require bankruptcy search done, but nobody's really thinking about that until it gets later in closing. I've sent the title binder to the seller's attorney, or, you know, if I'm representing both sides, you know, we're proceeding to closing. And then I say to my paralegal, all right, let's get our title application in order before we close. And they do a bankruptcy search, and we found out 3 days before closing they're in bankruptcy. Well, that's a shit show. I mean, that puts everybody in a bad spot. You know, everybody's crying. They don't understand how that could have happened. Well, it did. And it can't be sold. And we're probably looking at 45 days minimum to get it done if everybody wants to go through that process. If you're worried and you don't think the person's being honest, or you're uncomfortable asking them, email me and say, hey, Sean, this guy looks pretty rough. You know, I saw 8 envelopes in the mailbox that had credit, you know, due tomorrow, due immediately. you just run a bankruptcy search? I can run it in the Eastern District and we'll see if there's anything there. Next slide. All right. Another thing that delays a lot of my closings is when my flipper or my wholesaler forgets to tell me there's a tenant in the property. How could they possibly forget to tell you there's a tenant in the property? Happens all the time. Happens all the time. In fact, you know when it's usually found out is when I send the HUD to everybody and they go, where's the prorated rent and security deposit? I say, what prorated rent and what security deposit? Nobody told me there was a tenant in the property. It should go in the body of the contract. And then I should get a copy of the lease when I get the contract. And here's the thing, people don't realize this, but if they have a property management agreement, you know, with somebody, that can follow the sale. That doesn't just automatically terminate just because they sold the property. So I have seen many times a flipper sell, or a real estate investor sell to another real estate investor. They think, oh, sweet, I'm getting this rental to add to my portfolio. They manage all their properties. That's important to them. That's part of their income. And they got to deal with Dotson Property Management and pay 10%. And they're pissed. And they're like, why didn't anybody tell me this? And I say, why didn't you review the lease closely? And, you know, so that's just, those are things, these things happen. I'm not making these things up. I know it sounds crazy. And like I said, we talked about it earlier, the changes to the Landlord Tenant Act in Virginia have really made it harder to get tenants out. So you really want to make sure, not only do you have a nice lease in place, make sure it's not, you know, it's a really well done lease. Otherwise we can redo it before closing. You also want to make sure that it's the term that you want. Virginia recently changed it. It used to be if a lease didn't state a term, it was automatically month to month. Well, now it doesn't state a term, it's automatically a year lease. And that's have a pretty strong effect, I think, on some people that weren't expecting that on lease properties, buy and holds. I think that's it for that. You can go to the next one. I don't know if I have a next one. I think we're getting close to the end. Is that it?
Lenders.
Okay.
No, it looks like there's 3 more spot. Yeah, lenders is that one, and then there's some title insurance and closings.
All right, I'll hit on lenders real quick. You know, this is something I require now, and I think my lenders appreciate it. You know, I work with a fair amount of investors that use, you know, a handful of the same lenders every time. Is I want a written loan commitment, and in that loan commitment, I obviously want all the terms stated. Again, sounds very basic, but apparently it's not basic. Okay, I want to know whether or not a personal guarantee is required up front. I want to know exactly what the interest rate is. I want to know if the points are being paid at closing or on the back end of the loan. You know, I want to know the address for the lender to get payments. I want all of those things ahead of time because it's going to go into the title commitment. It's going to go into the loan docs I prepare, and they're going to go in the settlement that I prepare. So if I can do all that stuff at the beginning and I'm not chasing that information the day before closing, it's going to make your closing go smoother. And by all means, I like to get the contact information for the lender right away because I don't want the buyer sending me the title commitment. I want it to come from the lender for obvious reasons, right? I don't want to hear at the end, oh, that's not the form that I sent it in. I want these other things too. So I want to have communication with your lender, especially if they're asking me to prepare any loan docs. And if they're not, that's fine. But I want to see their loan docs ahead of time. I'm not going to review them in their entirety, but I'm going to review them for their recordability. So I want to make sure that they can be recorded at a minimum. If they have an attorney, I want to talk to that immediately. It may have particular requirements, commitment that I know about. And if I can make those changes, once again, that can be a delay. Another important thing is if they do require a personal guarantee, who do they require the guarantee from? Some of the lenders are really cool. And they're like, all right, well, I work with Sarah, and Sarah is the member of the LLC I work with all the time. I trust her. I just want her to guarantee it. Well, some of the lenders I work with say, I want to see the operating agreement, and anybody that's a member of that LLC is going to sign that personal guarantee. Also, some lenders are particularly insistent that even if, for example, I have an investment company and I borrow money, my wife is in that company, is not in that company, they still want her to sign the personal guarantee. You can imagine why, right? Because they can't get to my personal residence because I own it, going back to page 1, tenants by the entirety. And so we want to know all those things, because I can't tell you how many times I've gone to do a deal that we're all excited to close, and the day before they say, well, we want to make sure the wife signs the guarantee, and the wife is on one of those wonderful cruises, and she can't sign the guarantee. So we're in a tough spot. Now, we're in a great time for real estate because of the e-recordings. And in our office, we have what's called an e-notary. It's one of the best things that's happened since the e-recording. My law partner, Walter, can notarize something. We notarized something in Europe the other day. It's crazy. The guy just had to get on a computer. It's fantastic. Now, I'm going to go over your loan terms and fees at closing, but I can't tell you how many times people have come to me and they say, what do you mean I got to pay 2 points and a doc prep fee and funding fee on the back end? And it's a surprise. But I don't know who that's on, but I think it's probably on the buyer. They really need to understand their loan terms well before they walk into my office and not have that be a surprise. Next slide. All right, so somebody asked me to touch on title insurance, and I'm happy to do that. There's been a little bit of, kind of that, I don't know if it's on the dark web, it's not on the websites I go to, but this kind of spreading, like title insurance isn't needed. You had a title search. What the hell do you need title insurance for? You had title search. Well, that's just ignorance, right? Because the person that's doing the title search, while they might have errors and omissions insurance, they certainly aren't going to have, $100 million worth of, assets on hand that Fidelity or Old Republic or First American are going to have to help you with your claim. They're certainly not going to be able to pay for you to assert any of your rights under your title insurance policy that you might have. So I generally, if I close a deal without title insurance, I've got a waiver that I have people sign. But I wouldn't make a habit of it. If I had a client that wasn't getting it regularly, that wouldn't be one of my clients. Standard title insurance is 20% cheaper than enhanced. It's usually all you need is a flipper because you're not looking for some of the additional long-term coverages that your enhanced is going to give you. And that's all you can get with an LLC anyways. 90% of my clients are buying in an LLC and they don't provide enhanced coverage. Enhanced coverage does give you, extra stuff that OST is supposed to be post-closing fraud. You've heard of this new thing. A lot of people keep asking about it. Well, I hear there's people that are signing deeds over to properties they don't own and getting money off of it. Well, that would be covered under an enhanced policy. Encroachment, zoning violations, all those can be somewhat covered under an enhanced. An enhanced policy goes up, I believe it's 10% for the first 5 years. So some increased value, especially for people that are renovating. But the primary benefit of title insurance isn't when somebody knocks on your door and says, hey, I own this property, not you. And then you're in this incredible lawsuit for who owns the property. It's when you go to sell it. The 5 major carriers in the United States have an indemnity agreement that says, if I'm going to sell my property and I have a Fidelity title insurance policy and the buyer does a search and the search reveals a judgment, a prior owner judgment, they're not going to care about it as long as I have that policy. It's like a get out of jail free card. So they'll take that policy and remove the judgment from title. And I probably use that 50 to 100 times a year to save files from being delayed. If you don't have a policy, then they're going to have to fix that judgment. They got to go back and eliminate that person. They have to do all kinds of stuff. So that's where it comes in handy. On a refinance, it comes in handy because they're not going to run title for 50 years. They're going to run it from the date of the last owner's policy, which for you might just be 3 years ago. If you're, changing from private lending to 30-year institutional lending. So those are kind of the benefits. Ask me any other questions you have about title insurance. I know a lot about it. I just can never figure out what people want to know about it because it's so boring. So feel free to ask me any questions. Next slide. Yeah, this is kind of common sense. And this is usually when I'm talking to 50 or 60 people, I want them to understand the last thing we want to delay is at closing. I need a cashier's check or a wire I don't need the cashier's check payable to the seller. Sometimes they come with it. Seller, it needs to be payable to my firm. We have to be very careful about wire instructions these days. So we have very specific policies. Bring your ID to closing. If I'm notarizing loan documents, you got to have a valid ID. Be prepared to give me an address of where you want your tax bill and your deed to go to. And then post-closing, for the reasons we just talked about, keep your title policy in a safe place. You don't get that at closing. The title policy comes about 30 to 45 days after closing. So it's important that you put that into the packet that I gave you at closing, and you can find it when it's time to resell, refinance, or what have you. And that's kind of all I've got. So I'm welcome to answer any questions. I know I flew through a lot of stuff, but I know we don't have a ton of people. So I just want to kind of keep it quick and to the point.
Well, thank you, Sean. And I will be sending this out also to the group. We did have a couple other people try to join, but we've been kind of weird about letting people in tonight. Someone did ask if I can send them a copy of the slides. Is that okay?
Yeah, I think that's fine. I would just ask for you not to share it with anybody else. Like, keep it within this group. I just don't, you know, my fear is like it's shared with the wrong person. Next thing I know, somebody's using my slideshow to do something similar.
I see. Gotcha. So Amy, I'm going to send you, I'm going to put my email address. Amy was the one who asked. I'll put my email address in here, and then you can email me definitely. So, okay.
Sounds good. I think I see some questions. Chuck had asked, what would you say is the most common reason a contract is not? Yeah. So I mean, that's an easy answer. It's not signed by the right parties. You know, I mean, I think that if the contract isn't signed by the actual owner, it's unenforceable. Some other reasons is if it's doesn't have a mutuality of terms. Sometimes I'll see an investor contract that is so one-sided that the investor literally almost has no obligation to do anything. And you could have a court find, well, because the investor has no real obligation under this contract, it's not really enforceable. Which I think once you make a deposit, you kind of, you nail a little bit of that down. The other thing, and I know some of y'all have seen this, it will say something like subject to my partner's approval. Okay. So it's subject to a future event that is not defined anywhere. That very well may be an unenforceable contract. And I know people put that in there to be tricky, right? They're like, well, what if I want to get out of it? Well, if your partner is not identified and the parameters of their approval aren't identified, that may also be an unenforceable contract. So don't make it so vague. Don't try to be too tricky. Make sure you have some obligations, like to, give notice if you're going to terminate it within a certain amount of time. Just make sure that there's some, standard legal terms in there, and you're always welcome to send it to me to take a peek at. I don't see any other questions. Is it okay for the investor to do their own title search or danger? So I don't think, I would always ask the investor to do their own initial title search. I think that's a great idea, especially if you're getting a really good deal and you want to have an idea of what's out there. And the thing I didn't talk about is judgments, obviously, right? Because you might get down there and you're buying from Anna Johnson, and there's 100 judgments, and you're going to be overwhelmed, right? Well, my title company can deal with that. But at least you have some knowledge to say, hey, Anna, when I went down there, 100 judgments came up. Do you have any judgments against you? And she might say, I just moved here from Saudi Arabia. How could I have any judgments in Virginia? Or she might say, I moved here from Colorado. And then you're like, okay, then I'll let Sean know that, and I can kind of eliminate some of those. Or if she's comfortable, she can give me a social security number, and that will help eliminate them. Or she might say, yeah, I owe Virginia Credit Union, 10 grand, but that's the only judgment I'm aware of. And so we can go straight to that one. And the reason is I can eliminate those by judgment affidavit signed by her, but it gives us a great jumping off point. Anybody else have any questions?
Yeah, Sean, I've got a quick question for you. I'm a private lender. I always require a lender's title policy on our loans, but how is it possible that a borrower can then get another loan put in first position before us in the recording. First of all, is that possible? And how long does it take typically to record with the county that loan?
Okay, so I think I would say if I'm doing the closing, it's not possible, right? Because you are the lender, you've given me your loan instructions, your loan commitment, you're a first position lender. And so the way that that deal is going to work for me is I'm going to record the deed, and immediately behind that deed is going to be your deed of trust. So there's no opportunity for anything to be recorded between those two instruments. Now, if you're having another, like I can't really envision any settlement agent that knows what they're doing, or any attorney that knows what they're doing, allowing that to happen. A second deed of trust could be recorded at any time without your knowledge, but that doesn't sound like what you're talking about, is it?
Yeah, and I'm not really asking for myself. I'm asking
Yeah.
for some others that I've seen where they have made a loan thinking they're in first position. However, something else has been recorded in first position before theirs has.
Okay, so the question would be, did they confirm with their settlement agent that this is it has to be a first position loan? Number one. Number two, did they review their lender's title commitment? In the body of the lender's title commitment, it has to state any liens. If for some reason their lender's title commitment didn't show that lien, and their lender's policy doesn't have an exception for that lien, then as it relates to the title company, they're in first position. So they have title insurance as a first position lender. What does that mean? Well, it doesn't mean anything until the first lien was actually in the foreclosing process, because then they would have a claim against their title company that insured the loan. So honestly, the only thing I can think is they didn't explain to the settlement agent that they wanted to be a first position loan. They said, we're loaning $10,000. They got a lender's title policy. I'd be curious if they looked at it, it might show right in the body of that policy that they're in second position, and that first lien is.
I think that makes perfect sense. And I'm asking the question really just to better understand how this could have possibly happened. But I think what you're saying makes perfect sense. So thank you.
Yeah. All right. It looks like I got a question that says, if they don't give you their social security number, how can you find out if they have a judgment? So you go down to the clerk's office and you type in that name, that's going to come up. Some clerk's offices will have separate tabs for judgments. Most of them are now, it's just a major search for everything. But you can go into specific areas in the judgment liens. In Virginia, what's great now is that almost all clerk's offices are going to go back at least 20 years electronically, where you sit on the computer and do it. And that's all that matters really on a judgment. Anything older than 20 years is probably going to be an unenforceable judgment anyways. And so it doesn't even really matter if the judgment was entered 22 years ago in circuit court, it died 2 years ago. And so, now you can redocket a judgment. Very few creditors are out there, following up in 20 years and redocketing judgments. I'm not saying it can't happen, but you can usually go down there. And that's when you just have to ask the question. You just have to say, hey, is this you? There's really no other way. Now, you can sometimes be a little bit creative. If you really want to know, you can look up that person's name on Google, and some of the, like Intellius is a site, and you look up their name and you can see what addresses they're at, right? Like if the judgment is against Anna Johnson at the property address, it's her. Or if you know that this Anna Johnson used to live in Colorado or something, well, it's probably a bad example, but there's ways you can track it. You can also eliminate it if you know that one person was living somewhere for 10 years and the judgment was served somewhere else. Then you kind of leads you to believe maybe that's not them. So we do some of those things to kind of eliminate judgments. But at the end of the day, Anna has to sign an affidavit saying she's not a person. I'm not going to let her sign an affidavit saying it's not her if the judgment is against an Anna Johnson at the property address. So I hope that kind of answers the question. Anybody else got anything? Free legal advice, going once, going twice. All right, guys. If y'all
Very
don't have anything else
cool.
you want me to hit on, I think I'll wrap it up.
All right. All right. Sounds great. Yeah. If anyone else has any questions, that's awesome, Sean. Totally appreciate it. And the thank yous are coming in and such. So thank you so much. And if you want, I can add you. I know you mentioned about wanting to hear about the mobile home. I can add you to our investor group email that I send out with the links and things. And just don't come in as Sean. Make sure your last name's on there. We had a few people tonight.
I will be honest with you. I'm a Luddite. I have fought technology all my life. Zoom was the pandemic was, fortunately, we never slowed down at all, but I'm not good at this. So I'll have to ask Walter at my firm handles all this stuff. And I'll have to tell, he told me how to share the screen. It didn't work. So I don't know. He may not have a job tomorrow.
Well, I will tell you the problem with technology and with these things is they're always doing updates. Okay. So then you think you get it and you think you know it. And like tonight, we had 3 different options for sharing the screen. It wasn't just the one option anymore. And now it muted you. So I don't know. I'll have to figure that out.
It's frustrating. Well, I really appreciate you guys having me. If any of y'all have any questions individually, I'm happy to answer them. I know that you guys up there in Fredericksburg are thinking about coming down here. Feel free to reach out to me. The best way to get me is by email. I think it was in our first page that we showed.
I'll send it out tomorrow too with the recording. I'll send it out. So
I'm the only.
Yes, and I actually I'll probably make this available to everybody because there were people that were trying to get in, but we didn't know for sure because they only had like JD or they only had the first hacker guy. His name was John, and so we just didn't know. Yeah, it wasn't good. So we just didn't know who was coming in, and so we didn't let some people in. And so I've received some messages. So we'll send it out to everyone. I'll make sure to include your information. And, we'll make sure the information gets out there. So thank you so much. And to everyone here on the call and also to anyone listening, our networking meeting is actually next Thursday instead of the following Thursday. And we are going to be meeting at Wegmans. So it's going to be next Thursday at 6 o'clock, right? At Wegmans. And I'll send out reminders though. So I'll make sure to get it.
Thanks again. Y'all have a great night.
Thank you, Sean. Thank you so much.
Thank you very much. And
You're
thank you,
welcome.
Chuck, for giving his name. Thank you.
Definitely. Have a great night.
All right, you
Night,
too.
everybody.
Hey, man.
Thank you.
Sean.